SJC-11601, Commonwealth, Adam Simpkins.
Good morning, Mr. Sheketoff. I see you decided not to be silent for the last one and save yourself for this one, so you may proceed.
Thank you, if it please the court. Robert Sheketoff with me, Kirsten O'Brien, who was a trial lawyer for Mr. Simpkins. So I raised two double jeopardy issues. One is completely fact-driven. That's that the motion for required finding of not guilty should have been allowed. I rely on one case, which I think is the most similar case to this, Commonwealth versus Swafford. That was a co-defendant case. Gittins was the co-defendant. The facts in that case are more compelling than the facts in this case, and this court found that they weren't sufficient as a matter of law, even though I managed to convince a Suffolk County jury that they should convict.
Could I just ask you on that, just if you could go over a little bit of the facts. The white Taurus drove to 10 St. Mark. Can you just describe people walking and where the car was and who went inside when?
Yes, I think the state of the evidence is that about a week before, there's some dust up at the Dunkin' Donuts, and the white Taurus is there. And there were several people there, one of whom was identified as Mr. Simpkins. Now, moving a week forward, and there was an exchange of words, what's up?
And the two victims are there.
The two victims are there, and at least Mr. Simpkins is there, and several others.
But nobody says that Simpkins is the one that said, what's up?
Correct. Now we move forward a week. The key eyewitness for the Commonwealth sees the two shooters, by inference the two shooters, walk in the direction of the scene of the shooting. After they've walked in that direction, the white Taurus shows up at 10, at the address of 10. And the people in the white Taurus get out, go into the house. The shooting happens, and then the two people flee back towards, the two shooters flee back towards that address. The Commonwealth said to the jury that we have no evidence that Mr. Simpkins is one of the shooters. So their theory is that it goes something like this. He was involved in the dust-up. Neither of the shooters was involved in the dust-up because they weren't identified from the photographs by the one witness that remained alive. Therefore, Mr. Simpkins must have told the shooters about the dust-up. They were doing his bidding when they went and shot these people. And the reason we know it's related to the Dunkin' Donuts incident is because they said, what's up now, before they started shooting.
Well, they would add that they go by very quickly after the car comes, they run back to the house, they are let in, and the guns are behind the...
Right, they're let in. I mean, they got into the house. There's no evidence about some specific person letting them in or that the door was locked or anything like that. Yeah, and in Mr. Gittins' case, in the Swafford case, the evidence was much more compelling. The fight happened within a 24-hour period. The only two people there were Mr. Gittins and Mr. Swafford from one side. They're in a street gang. Another street gang was targeted, I can't remember, it was after midnight, but within a few hours. And it was Mr. Gittins' car that was used, and he met the description of the driver of that car. Mr. Swafford was the one shooting out of the car, because he was a black male. It wasn't much of a description, but it was a description. So that's a fact-driven case. I think I win on that. I'd like to address what I think is a more interesting legal issue, which is much more law-driven. And when Chief Justice Gantz was a single justice, he's the one that reported this to the court, and he said the real issue on issue number 2, the accessory after the fact question, is whether or not you can't be convicted of being the murderer and the accessory after the fact of murder, whether you cannot be convicted, that's inappropriate, or whether if you are convicted of both, you can remedy it by just dropping for dismissing the least
Is
serious
this-
charge.
Is this case a question of what is the law on the point that you just described? Or is it a question of, is it the law of the case? Because didn't the judge tell the jury that they couldn't?
Right. I agree with that idea that whether it's the law or not, it may be the law of this case. But I think it's also the law. It's always been the law of this Commonwealth that you can't be convicted of both,
Well, can I just, but,
But you can be
okay.
prosecuted for both.
but you can be prosecuted.
Okay, so what, you would agree that if the jury had come back with a guilty verdict on this, that the judge following, however you pronounce,
Gajka.
Gajka, following Gajka.
Not saying I'm pronouncing it right, by the way.
Could have done exactly what happened there, and only, right, or not?
No, I'm not going that far, because Gajka is a special case, because in Gajka, at least the way I read this court's opinion, the jury was not instructed on the fact that you can't convict of both. When they came back and convicted of both, the defense lawyer did not say to the judge, send them out again. These are inconsistent verdicts. And in those circumstances, this court said the appropriate remedy could be dismissal of the least serious charge. In some sense, Your Honor, you put your finger on the issue I wanted to focus on, which is this. If I'm trying this case before a Superior Court judge, and that judge tells the jury you can't convict on both, and the jury does return verdicts of guilty on both, what do I do as the defense lawyer? What am I entitled to? And I think that's critical in this case. I say what I'm entitled to is to go to the sidebar and say, Judge, these are inconsistent verdicts. They make no sense as a matter of law. You cannot find he's the principal and that he aided because he was not the principal simultaneously. You have to re-instruct them. You have to tell them that they can't convict on both and ask them which one they're finding him guilty of. And if that's correct, then I think I win the case. And if it's not correct,
Because but you would also, and I take it you would say that in the circumstances that happened here, because the jury didn't find anything, the only appropriate way to interpret that, given the judge's instruction, is that they felt they didn't have to, since nobody asked them, they felt they didn't have to reach it because they had found him guilty of accessory after the fact.
yeah, that's exactly what I think, because I think a jury following these instructions would have said to itself, once we find him guilty of accessory after the fact, we don't even address the murder indictment because we weren't told that we have to acquit on one if we convict on the other. We were just told we can't convict on both. And the appropriate way to respond to that would be what this jury did, which is pick the one you want to convict on, if either, and not address the other.
So is it your view that an element of the accessory after the fact is that you were not a perpetrator of the crime?
Absolutely.
But then what do you have in a situation like this if, let's assume, 6 jurors thought he was the perpetrator and 6 thought, but all 12 agreed, well, I'm not sure if he was the perpetrator, but I know that he was certainly somebody who helped hide the guns.
Okay, so I see it, Your Honor, as very similar to Figueroa in a way, the case you just decided about soft transitions. Because you could be in the exact, I mean, I don't think of this as a lesser included offense. I think of it as a lesser excluded offense. But I think it's, the analogy is similar. So as a generality, we're trying to promote rational fact-finding. That's our goal as a court system. And so we have this concept of lesser included offenses, and we have this concept of lesser offenses, whether they're included or not, that give jury all kinds of rational ways to think about the case. So if I'm a juror, and I think in my situation I'm in a stronger position than in the soft transition cases where there's lesser included offenses. But if I'm a juror and I think the guy's guilty of first-degree murder, but only 6 of us do, and the other 6 think he's guilty of second-degree murder, without damage to my personal conviction about what he did or didn't do, I can vote guilty for second-degree murder because he is, in fact, guilty of second-degree murder, too. It's perfectly rational and consistent for me to say, yes, he's guilty of second-degree murder. If I can't convince you he's guilty of first-degree murder, so be it. But there's no harm in me saying guilty of second-degree murder. But in this case, accessory after and actual murder, if I'm a principal juror trying to act rationally and I believe he's a perpetrator, I cannot find him guilty of accessory after the fact. I can't do it. That would be a violation of my oath. That's a compromise that I cannot make unless I want to admit it's a total compromise.
I should know this and remember, what were the instructions as to the elements of accessory after the fact?
That you aided another. So that
Aid another to
get away with it, basically. You don't have to have the state of mind of the person perpetrating the crime, but you have to know that they committed a certain crime.
So if that's the case, I'm back to Chief Justice Gantz's question. If that's what they were, why do you say it is an element of accessory after the fact that you can't have been a perpetrator? I mean, you could still aid. If you have a bunch of perpetrators, somebody can still aid.
I was wondering if someone would ask me that question, but no, not according to our case law. If you and I commit a crime together, and I'm a perpetrator and you're a perpetrator, and I help you afterwards in a situation where I would be an accessory after the fact, I'm not guilty of murder and accessory after the fact. If I'm a principal, I cannot be guilty of murder of accessory after the fact, even if there are several others participating.
It would be under our law just a continuation of the joint venture that you're.
Yeah. So,
Well, what do you make of the fact that?
and if I'm wrong about that, I apologize, Justice Spina. If I'm wrong about that, then I have a problem. But I don't think I'm wrong about that. There's no case that's ever suggested I can be an accessory after the fact of something else, some other co-defendant as a principal. And I think it would actually be a total defense, not that anyone would do this, but I think I could defend and get an instruction from the trial judge that if you believe this defense, you have a reasonable doubt about it, you must acquit. I could defend by putting my client on the stand and say, I wasn't an accessory after the fact. I killed the person. I think that's a complete defense to accessory after the fact. Just like in Berryman, I think, the earlier case than Gotcha, the lawyer tried to sneak around the Commonwealth's right to try you on the most serious offense by pleading guilty to accessory after the fact and then claiming, oh, now you can't prove the underlying crime because I've already pled guilty and these things are inconsistent with each other. No, that would be a game that, in Gorton and a lot of other cases you've said, you can't plead guilty to a lesser crime and stop the Commonwealth from trying to prove the greater crime. But I think it would be a defense to a charge of murder to put my client on the stand and say, I'm guilty of accessory after the fact. I did that. And therefore, if you believe me, the jury would be instructed. If you believe them, you have to acquit them of the murder.
If getting back to your point about a juror couldn't, in good conscience, vote both ways on one of these things, what do you make of the fact that the jury, that some of the jurors anyway, the jury was still deliberating on the case of accessory before the fact? Is that some indication that, this was just a conditional verdict on the accessory after the fact, that we hadn't really made up our minds about the entirety of the case?
Well, I take the position the way to rationally view what the jury did is once they found him guilty of accessory after the fact, they never deliberated. They didn't feel they had to acquit him of the murder charge. They never deliberated on that charge. But even assuming that...
Why were they hung?
They were hung on there were other indictments to be hung on. It's not 100% clear that when they said they were hung, they meant that that 6 of them were on one side on this particular indictment. They hung on the co-defendant. They hung on the armed assault with intent to murder. So I think the rational way to look at it, since we assume jurors obey their instructions, is that they never address that issue once they concluded that he was an accessory after the fact. But assuming for the minute that you're correct, Your Honor, that you can read this record to say some of them thought he was an accessory after the fact and he was guilty of the more serious crime, I see it the same as Figueroa. You know, there's an implicit finding that you're not guilty of the other, even if some jurors are not obeying their oath correctly, because these things are mutually exclusive. You can't be both. And that's what happens in the soft transition of Figueroa. We realize that there may be people that are voting for murder in the first degree, even though the jury's returned a murder in the second degree conviction. Thank you.
Thank you.
Good morning. May it please the court, Kaylin Campbell on behalf of the Commonwealth. With me today is the trial prosecutor in this case, Mark Lee. I'd like to start, as my brother did, with the sufficiency of the evidence in this claim, and I think Swofford is an excellent case to start with, because this case can be distinguished from Swofford, specifically because in Swofford, this court said that the problem with the evidence in that case was that there was no specific evidence linking the defendant to the shooter in the minutes after the shooting. Integral to the decision was that while the Commonwealth proved it was the shooter's car, while they proved it was the defendant, in that case, Gibbons' car, they never proved that Gibbons was in the car or with the shooters in the minutes after the shooting. And looking in that, when you look at that specific concern, it is not at play in this case, because there is overwhelming evidence that in the minutes after the shooting, the two shooters ran directly to the defendant's house. But there's more evidence than that.
Their good friend.
He was their good friend, Your Honor. But looking at the evidence in the light the most favorable to the Commonwealth, what you have is you have the dust-up the week before. Mr. Simpkins is the only individual who is identified as being in that dust-up. You have the words that are spoken, "What's up?" Now, while Mr. Simpkins is not identified as being the person who specifically...
You're not going to suggest that "what's up" are somehow a non-used phrase that is tags the person who says it, are you?
I don't believe it tags the person who says it, but I believe where you have the shooting in conjunction with that dust-up, and they say, "What's up now?" Looking at the evidence in the light most favorable to the Commonwealth, you can't discredit the fact that it is similar.
What's up now? What's up now? I mean, how do we know? I mean, it doesn't mean anything.
Your Honor, I would say that the way that it is in the transcript, it's "what's up, comma, now." There was...
I don't think that was there.
How was the comma reflected in the evidence?
But you would have to listen to the way that Jones, who is one of the victims in this case, testified as to the way that they said "what's up." And certainly it wasn't a friendly "what's up," because they say "what's up," and then they immediately open fire on these two victims. I can say that when someone says "what's up now" and then begins to shoot at you, it's not a friendly "what's up."
Okay,
but more than that...
That's just such common street language. I mean, how do we make anything of that? I mean, that's not a way to distinguish this case from Swofford, because everybody says, "What's up? What's up now?"
Your Honor, while everyone does say it, there was specific evidence that tied Adam Simpkins in a dust-up the week before where they say "what's up" to the victim, and the victim says, "Ain't shit, what's up?" And then
that's just...
He did, though, correct?
That's just so...
He was part of the group that did.
It's clear that this standing alone would not have much significance.
Correct. This standing alone wouldn't, and we wouldn't. I wouldn't be making this argument if that was the only evidence that we had.
If I could focus on the retreat to the house.
Sure.
Is it your position that that is sufficient because he's a joint venturer in the escape? Or are you saying that, no, you'd have to show that he solicited the crime?
I actually think that both would show participation as required under Zanetti. I think that there's a reasonable inference based on the dust-up and the words, although it may not be agreed upon by all the justices, that shows where the two shooters weren't identified as being there. It shows that he solicited them and told them about it. But more than that, I would say that there's an overall plan. The two shooters were identified as being on St. Mark's Street prior to the shooting, walking up and down the street. 10 minutes before the shooting, they are seen walking near 10 Marks Road. 5 minutes before the shooting, a white Taurus comes up. It's the same white Taurus that was involved in the dust-up the week before. The defendant is identified as getting out of that car. Notably, the white Taurus is visible from the scene of the shooting, which is across the street about 200 yards away. So certainly the shooters, it was capable for them to see that the white Taurus was parked there.
When you said 10 minutes they were near St. Mark's Street, how far were they? St. Mark's Street?
The 10 minutes before, one of the witnesses, Ms. Golden, testified that she actually saw them cross in between 8 St. Mark's Street, cross in between 10 and 8 St. Mark's Street. So they were right next to 10 St. Mark's Street, 10 minutes before the shooting.
So was there any evidence that Mr. Simpkins was part of a gang, or that he was the leader of a gang?
No, Your Honor.
So this is not a situation in which we have strong evidence of a hierarchy with Simpkins at the top.
No, Your Honor, it was Mr. Simpkins' house, though. So Mr. Simpkins did live at 10 St. Mark's Road. So it was the Commonwealth's theory throughout that Mr. Simpkins, that was the base camp of operation, where the shooters are seen walking up and down the street before, where they wait until a couple minutes after the white car and the defendant gets home to conduct the shooting, despite the fact that the 2 victims had been sitting on the porch all day. It supports an inference that it was part of the plan that the defendant be home before they commit the shooting.
Describe for me where the victims were vis-a-vis 10 St. Mark's Road?
Sure. And I think the easiest way to do that, if you look in the Commonwealth's record appendix on CA-25, there's a map of the area that it was in. They were at 31 Roseland Street, and the testimony was that they were sitting on the front porch. Mr. Jones testified that from the front porch on 31 Roseland Street, he could see the white Taurus, and he could see 10 St. Mark's Road, which is also highlighted.
Did Mr. Jones, I think there was testimony that he had seen the defendant in the neighborhood.
Correct.
Right? Was there any other connection between them?
Between the two, aside from the dust-up the week before, no. Or at least not anything that was put before the jury.
Jones didn't testify to any motive or nothing, no connection.
Aside the week before, that dust-up,
right.
yes. But other than that, no, Your Honor. But this is certainly an area that is close. I think it was stated on the record that it was 200 yards in distance apart from the two. But more than that...
And how much time elapsed between the time the defendant got home and the actual shooting?
5 minutes. 5 minutes.
Did he go into his house?
He went into his house. There was also testimony from...
But did they go into his house after he went into his house?
There's no
and
testimony...
before the shooting?
No. Ms. Golden loses sight of them, so there's no specific testimony that they are seen going into the house. What there is specific testimony is that in the minutes before the shooting, a maintenance man at St. Mark's Church, he sees the 2 shooters standing huddled as if they're plotting, waiting to do something. So there certainly was a pause, a hesitation before they went and opened fire on these 2 victims. But turning to the actions of what the shooters did once they got to the defendant's house, and what the defendant did once the shooters get there, I think that is also indicative of the defendant's intent and participation in this murder. This isn't a case where someone just handed him a piece of evidence and he hid it underneath his pillow. He took these guns apart, he wrapped them in tinfoil, he doused them in cinnamon, and he concealed them to an effect that he put them in drywall. It is as if he destroyed this evidence. And it's this concealment that is akin to escape. I think on these facts...
But how, okay, you say that. The jury has been told, define the crime of accessory after the fact. They've been told you can't find him guilty of both. Why should we interpret that as part of the murder as opposed to very strong evidence of accessory after the fact, given what the jury did?
I'll answer that in 2 ways. The first is as to the sufficiency way. I think it's important if you look how they were instructed as to joint venture murder and accessory after the fact. They both talk about aid and assistance given as to escape. Those exact words are told to the jury as to both crimes. So the question really is a question of intent. Is this the type of aid and assistance that's given that can support intent and participation in this murder? I think it's important on these facts that the Commonwealth never alleged that Mr. Simpkins was one of the shooters. It was our theory the entire time that he was a participant in this murder, and his intent would be shown by his actions before the murder and his actions after the murder.
But let me ask you this. Let's go to Mr. Sheketov's point. Let's assume the jury had come back guilty on both, where the judge had just instructed them that they couldn't do that.
Yes.
What should have happened at that point?
Under Gachka, the accessory after should have been dismissed.
Jury shouldn't have been sent back with instructions that they can't do this and they've got to decide
They could have been sent back. Yes, Your Honor, they could have. It could have been dismissed or they could have been sent back. But I think it's important that this...
Well, how could it have been dismissed? The judge had instructed them that you can only find them guilty of one. He told them that it's inconsistent, that result would be inconsistent. So they're not following his instructions.
That's correct. Yeah, yes, on further reflection, where it is that, I think the appropriate action would be to send them back in to deliberate. But I think it's important to look at what happened here, in that after 4 days of deliberations, they came back and they said, we've reached some verdicts as to some. We're not in agreement as to all of them. The judge then instructs them a Tui Rodriguez charge. They're sent back out and they're told to keep deliberating. Now, what we don't know is what verdicts they reached before that point and what they were still deliberating on. And it's the defendant's burden here to show, under his collateral estoppel claim, that the first-degree murder claim was necessarily decided. And where you have a hung jury and they're given Tui Rodriguez, they're sent back out to deliberate. They come back one more time and they say, we still can't decide. The judge then asks, they are then sent back out to deliberate. Under Rule 27 of the Mass Rules of Criminal Procedure, what happens in that instance is that the judge tells them, see what you can decide upon. See if you can reach any consensus. So I don't necessarily think this is a case where they say, we find him guilty of accessory because we don't think that he committed this murder. I think it's a case where they say, because we're hung and they're told, go see what you can agree on, they say we can agree at the very least that he committed these crimes, which constitute accessory after the fact, but we're really struggling as to whether that is indicative of the intent to show that, or that he participated or had the intent for this murder. So there is nothing to show which verdicts were reached when, and they are hung on these two separate occasions. They are told to go keep deliberating. I think in that instance, you can't say that they necessarily decided that the defendant in this case is not guilty of the murder.
Can I ask you this? What happened to the other defendants, the co-defendants in this case? I really hadn't focused on the fact that there were 4 defendants on trial here.
There were. 2 of them were directed out because there was no evidence of anything other than they just happened to be in the house. They hung as to the other defendant, Mr. Perkins, and he was retried in March.
And?
He was found not guilty. He was identified as being one of the shooters, though. So I think it's important here that in this case, it was never said that Mr. Simpkins was one of the shooters. It was never suggested that he was a principal in the way that my brother spoke of principal liability. It was always that he was a participant in this crime, and he wasn't the one that actually pulled the trigger.
Do you agree with Mr. Sheketov that an element of the crime of accessory after the fact is that you are not a perpetrator of the crime?
No, I don't. I think the elements as they stand clearly don't say that. When I was researching back to see why you can't be convicted of both, if you go to...
Or why you can't be or why you can't stand convicted of both?
Why you can't stand convicted of both. If you go to Berryman and you go to the case that Berryman cites, ultimately you end up at Haskins, which is an 1880 case where the defendant is alleged to have stolen a cow, and he was charged with stealing the cow and receiving the cow as stolen property. And the court said, obviously, that's legally impossible because one of the elements of receiving stolen property is that the property is already stolen. And the court, what they said is you have to look at it and ask, on the facts that are given, is it inconsistent and impossible based on the context of the trial and the way that the evidence came out? And if you extrapolate that to here, I don't think on these facts that you necessarily can say that, where there is this question of intent and where both of the crimes do speak about this activity and this participation after the fact of the crime. And the question really is, the jury really, I think on these facts, seem to be struggling with, is this the type of participation that rises to the level that shows that this defendant had the intent to commit this murder. If the court has no further questions, the Commonwealth will rest on its brief.
Great, thank you.